Back on January 5th, the FTC proposed a new rule which would ban non-competes across the country at the federal level. Among many highlights to that rule are one, that it would be retroactive, meaning that it would go back in time for non-competes that are already on the books rather than having them grandfathered in. Additional highlights of that proposed rule, if you could call it that, would also include substantial penalties per violation, and I think even per day. And one of the things that has not really gotten a lot of attention, but actually came up in an excellent article on Law 360 that was published by some of my colleagues, and that is, what about at the state level? What type of domino effect might this have in terms of how the different states handle this proposed rule, whether it passes or not? And they point out, correctly in my view, that the state's attorneys general might view this as an opportunity to start shoehorning the non-compete agreements into the state unfair, deceptive trade practices acts. Now, these are different types of statutes that are in place in each of the 50 states across the country, and these statutes are phrased rather broadly, where it's deemed unlawful to engage in any unfair or deceptive trade practices. And each of those empower the states to impose penalties at the civil level for violations of these acts. Also, in many cases, like New York, they will often have a provision within those statutes that also allow individuals rather, to bring private causes of action, meaning not on behalf of the government, for violations of those statutes. And theoretically, this could open the floodgates to class action litigation, as they point out in that article as well. And that is something certainly to bear in mind as we go forward, because the FTC discussion is not really limited to the federal level, but we also have to consider what other implications might be coming down the pike. So the takeaway for employers who have these non-compete agreements on the books, in my view, would be as follows. Number one, to the extent that you have any non-compete agreements that are targeting or specifically dealing with lower wage employees, you certainly, at least from this point forward, want to stop doing that, because you're all but inviting governmental intervention into your actions. Rather, I would strongly urge you to limit your agreements with these employees to non-solicitation agreements, because at least in theory, the business has a far stronger legitimate business interest that is worthy of judicial protection when you're saying, just don't hurt my bottom line. If you have any further questions about this topic, please feel free to give me a call. My name is Jonathan Cooper, and my number is 516-791-5700. Thank you, and have a good day.